Mediation is one of the most effective tools in family law cases, offering a structured way to resolve disputes outside of court. Whether it's a divorce, child custody arrangement, or property division, mediation gives families the opportunity to make decisions together rather than leaving everything in the hands of a judge. It's faster, less stressful, and often results in solutions that work better for everyone involved. Texas strongly encourages mediation in family law disputes. In fact, many courts require it before a case can go to trial. The process is designed to help families find common ground while minimizing conflict, reducing legal costs, and avoiding lengthy litigation. Mediation allows for a more personalized approach, giving families the chance to craft agreements that fit their unique needs rather than relying on a one-size-fits-all court order. So, what exactly happens during mediation, and how can you prepare to get the best possible outcome? First, it's important to understand that mediation is not a trial. Instead, a neutral third party, the mediator, helps guide discussions between both sides. The goal is to find a compromise that works for everyone, especially when children are involved. When preparing for mediation, one of the first things to determine is whether mediation is required in your case. Many Texas courts mandate mediation before allowing a case to proceed to trial, particularly in custody disputes. If there is a history of domestic violence or other safety concerns, the court may waive the requirement. However, even if mediation is not mandatory, it is often beneficial. It allows families to retain control over the outcome rather than leaving decisions up to the court. Choosing the right mediator is also critical. A skilled mediator understands the legal complexities of family law and can guide discussions in a way that keeps negotiations productive. They don't make rulings, but they do help both sides communicate effectively and explore solutions that might not have been considered otherwise. If emotions are running high, a strong mediator can keep the conversation on track and prevent discussions from turning into arguments. Preparation is key to a successful mediation. This means gathering all relevant documents, financial records, property appraisals, income statements, and any agreements that might already be in place. If children are involved, records related to their education, healthcare, and extracurricular activities should also be on hand. The more information you have, the smoother negotiations will go. Another important step is setting clear goals. Before going into mediation, take time to identify what you want to achieve. What are your non-negotiables? What areas are you willing to compromise on? Having a clear plan will help you stay focused and avoid making emotional decisions in the heat of the moment. Mediation works best when both parties come in with realistic expectations and a willingness to cooperate. It's also crucial to prepare emotionally. Family law disputes can be stressful, and mediation can bring up difficult conversations. Take time beforehand to center yourself and approach the session with a problem-solving mindset. Remember, the goal is not to win, but to reach a fair and workable resolution. If needed, consider speaking with a counselor or legal advisor before mediation to ensure you are mentally prepared. During mediation, active participation is essential. Be ready to listen to the other party's concerns, express your own needs clearly, and work toward a compromise. Mediation allows for creative problem solving in ways that a court may not. For example, a custody schedule tailored around work and school commitments is often more effective than a standard court-ordered arrangement. If mediation is successful, the agreement is put into writing and signed by both parties. In Texas, a properly executed mediated settlement agreement is legally binding and enforceable. This means once it's signed, neither party can back out. That's why it's important to ensure the agreement reflects what was discussed and that all terms are clearly understood before signing. If mediation does not result in an agreement, the case will proceed to court. However, even if mediation does not completely resolve all issues, it often helps narrow down the disputes, making the court process faster and less contentious. Mediation is also useful after a court order has been issued, life circumstances change, and sometimes custody arrangements, child support, or other agreements need to be modified. Instead of returning to court, mediation provides a way to negotiate adjustments in a cooperative manner. For those dealing with cases involving child protective services, mediation is often required before a judge makes final decisions. These mediations involve CPS representatives, attorneys, attorneys and family members working together to create a plan that prioritizes the child's safety and well-being. Ultimately, mediation is about finding solutions that work for everyone involved, especially in cases that affect children. A judge will never know the details of your life as well as you do, so taking the opportunity to work through issues in mediation often leads to better outcomes. If you are facing a family law dispute and mediation is part of the process, preparation is key. Know your goals, gather your documents, and work with a legal professional to understand what to expect. Mediation is a powerful tool that can help you resolve disputes with less conflict, giving you more control over the future of your family. If you need guidance on mediation or any other family law matter, the attorneys at Varghese Summersett are here to help. Our team includes experienced mediators who can walk you through the process and fight for your best interests. Search for Varghese Summersett on Google. You can call us at 817-203-2220, or you can visit us at versestexas.com.